So again, thanks for joining us. My name is Karen Corman, and I have the privilege of being the Executive Director of the UIC Alumni Association. Welcome to the UIC Alumni Exchange Series. Through the UIC Alumni Exchange Series, we work to bring our alumni and friends a variety of programs and topics so you can explore, connect, and even escape from the everyday with a community of UIC alumni, faculty, and staff experts. You'll hear me say this a few times today, and I'll put it in the chat here in a few moments. But I encourage you to visit go.uic.edu/alumni exchange for the latest and the greatest programming. And with that, I'm excited to start this program today, as we are joined by several distinguished guests today to discuss tenants' rights and fair housing. From our UIC Law School, staff attorney Nick Kurutz will discuss common landlord-tenant disputes, and clinical director professor Allison Bethel and outreach coordinator Tony Gomez will discuss fair housing considerations and the impact of COVID-19 on them. We're excited to have all three of you here today, as moving season is just around the corner, and I'm sure they'll have lots of people here will have questions and comments. So thank you for being with us, and I'll turn it over to you, Professor Bethel, to begin the program.
Well, thank you so much. Thank you so much. And good afternoon, everyone. Thank you for joining us wherever you're joining us from, and even those who might be watching this virtually later. We appreciate you all. Some of you may not have known about the Fair Housing Clinic. Indeed, some of you may not have even known about the law school because we are the newest member of the UIC family. We joined UIC in August of 2019. We were formerly the John Marshall Law School, and we had been operating in Chicago as an independent law school, gosh, for around 100 years. And the Fair Housing Clinic was actually formed in 1993. And we have since then been working on fair housing issues in Chicago and throughout the country. One of the reasons that we wanted to talk to you today, and as was mentioned, we know that spring is coming, despite these temperatures we're having here in Chicago today. And that often means, among other things, that we get into moving season. At the Fair Housing Clinic, typically our phones and emails begin to ring off the hook as we get into the season. So we thought it might be a good idea to just share with you some things we're seeing in this moving season. It's particularly unique because, as many of you know, we are hopefully, at the end of a lot of pandemic emergency measures that have been put in place that affected housing situations. So we have focused this presentation to some extent on issues that we're seeing in what I'll call the moving landscape as people are moving around more. But in the Q&A, we're happy also to take perhaps more general questions. I want to start by just telling you really a little bit about the fair housing laws. You've probably heard about these laws. They were, of course, initially passed in the late 60s and then amended about 20 years later to extend protected classes. One of the things that the laws were designed to do was to sort of end a lot of the discriminatory practices that were in place before the laws came about. Things like restrictive covenants, which were agreements between private parties to limit the people who could move into the neighborhood. Zoning laws also limited where people, and particularly people of color, African Americans and other ethnicities, where you could live in Chicago. And there were just a number of government and private policies that created these separate and unequal communities that we have in Chicago and actually throughout the country. And these communities we have seen in the COVID pandemic have been particularly vulnerable to the ills of COVID. The Fair Housing Act, when it was passed with two broad purposes, one was to eliminate segregation, and we see that a lot. That might be what you're most familiar with it for, where you are prohibited from discriminating based on various classes. But the second piece of the fair housing laws were designed to foster integrated communities as a national policy. Integrated communities are more healthy, are more vibrant, and provide more opportunities. Sadly, we have seen how the pandemic has particularly affected Black and Brown communities. This slide just kind of shows you how we've had about 29,000 reported instances of discrimination nationally. And this was fairly consistent with what we saw in 2020, but we know that housing discrimination is rarely or often underreported because many times people don't know it happened to them. Things that we have seen in the pandemic that are particularly devastating have been a rise in hate-related activity against Asian American and Pacific Islander communities. We have seen a rise in sexual harassment claims, particularly involving women with the stay-at-home orders. Sadly, we've also seen instances where landlords have refused to accept emergency rental assistance and other measures that were implemented to try to minimize the impacts of the pandemic. And actually, in the few months since the moratoriums on evictions have been lifted, and Nick will talk more about that, but basically rents have been skyrocketing all over the country as landlords have, honestly, for the first time been in 2 years, right, been able to legally, let me go back to that other slide. I'll let you know when we want to advance it, but really they've only now been able to legally raise rents, and because of that, it has really even further crunched the housing market. Pandemic has forced a lot of mom and pop businesses, mom and pop landlords out of businesses, and foreclosures have put a lot of people in the rental market in the last few months, essentially making it a very, very tough, competitive rental market that we're seeing right now. Okay, now the next slide. He was anxious to show you this slide because this slide is telling you about our fair housing clinic and what we do. And as I said, we enforce the fair housing laws in Chicago through litigation and education and outreach initiatives like this to future lawyers and to change agents, which we hope will be some of you as UIC alumni. We are thrilled to be part of the family that has the only school, law school in the country with a legal clinic devoted exclusively to fair housing law. You know, as I say, we joined in August of 19, and then everything was shut down in 2020, March of 2020. So if you have not had a chance to visit the clinic or the law school or anything, we certainly hope that as things open up, we will get to know you better and become, really part of the family. All right, and let's advance to the next slide. Okay, so this is the professor's quiz here, the first quiz question. I actually like to call them multiple guests, and I'm not going to call on anyone. In law school, there's a Socratic method of teaching where you call on people, and it can be kind of a nervous experience. But here, I'm just going to ask you if you put what you think is the answer to this question, perhaps in the chat. And this question asks, which of the following categories of people do you think are protected by the fair housing laws? We've got recovering addicts, abuse survivors, formerly incarcerated persons. Oh my gosh. Okay, I'm getting some answers. Okay, well, great guesses. And the correct answer is actually F as in Frank. And I see that a number of people have gotten that. One of the reasons that, and Tony, we can go to the next slide. But one of the reasons why I wanted to discuss that is because I know that most people may be familiar with what I call the traditional federal 7 of the protected classes. The federal law protects these 7 classes: race, color, national origin, religion, sex, familial status, and disability. The first 4 were in the act in the beginning. Sex was added about in the mid 70s, and the last 2 came along in the mid 90s. But what people often don't realize is that we have state and local laws that provide more protected classes. State and local fair housing laws expand the protected classes. And some of the ones that are protected in Illinois and in the Chicago area include some of the ones on the prior slide. There are fair housing protections for formerly incarcerated people in Cook County and in Chicago, and to some extent in the state of Illinois. Victims of domestic violence, abuse survivors are protected under the Illinois law, and they may also be protected under the sex provisions, under the disparate impact theory, under the federal law. Persons in recovery from substance abuse may be protected under the disability laws, both locally and under the federal law. So one of the first takeaways I want you to appreciate from here is that the federal 7 are really broader than what you may see here. And when you look at what the protections that are also provided under the local laws, you can see that we have a number of protections here that can help you both while you're in your housing, if you're experiencing problems, or while you're doing your housing search. And the next slide. Okay, and this is our second multiple guess. Which of the following properties do you think are covered by the federal fair housing laws? Just throw your selections in the chat. For those, if you're joining us by phone, we have vacation homes, nursing homes, dormitories, shelters, vacant land, none of the above, or all of the above. Okay, so I can see that you guys have figured it out, and the answer is G, all of the above. And, you know, a lot of people are often surprised by the scope of housing that is protected under the fair housing laws, because you often think about, you know, your house or your apartment, but these more temporary type shelters, we often do not think about. And we certainly, yes, Ms. Harris, vacant land. We certainly don't think about vacant land, but the framers of the Fair Housing Act thought about that. And vacant land, if it is going to be developed for residential purposes, is covered under the Fair Housing Act. And of course that, well, in theory anyway, can help ensure that we build, you know, housing that is inclusive and available to all people. But one of the reasons that I wanted to get you thinking a little bit about the scope of properties that are covered is because in this housing market, where, as I mentioned, things are so tight, they are so constrained, we have a lack of housing, particularly affordable housing and accessible housing that people are needing. One of the issues that we're seeing is what I'll call this more temporary type housing. Things like dormitories and sober homes for people that you may need to live just temporarily, right? Even things such as home shares have come under the scope of the Fair Housing Act, Airbnb and this type of thing. And so thinking about this helps you realize the breadth, you know, how broad and deep the laws are and how they can protect you in a variety of situations. And again, including as a rehab or nursing home, as both when you're young and when you get older. And then notice this little note down here, which I'm not going to go into detail about, but the state and local laws may include other housing that is not included under the federal 7. So the big takeaway from here is that there is really much more housing covered under the fair housing laws than you might have initially thought. Okay, and let's go to the next slide. Okay, so this is the meat of it. What is considered discrimination? And certainly flat out denials where they say, I'm not going to rent to you based on your race or your sex or something. I think we all know that, but often it comes in a more subtle form. And I want you to know that that subtle conduct is just as discriminatory as the in-your-face statements that we saw back before the law was passed. And some things that we are seeing now that sort of amount to a refusal include things like income policies, for example, and we're seeing a lot of these income policies where first of all, many housing providers want to see how much income you make, of course, to see that you can afford the apartment, but issues come up in terms of what income they are considering. Sometimes they will not give the same consideration to sources of income like alimony and child support. Public benefits is a big issue in that we're seeing here in Chicago, including refusals to accept monies distributed through the different emergency relief programs. All of those kinds of things may be actionable under the local laws here in Chicago and Illinois. So discouraging policies and some other things we've seen are very strict identification policies, right? You've got to have a driver's license and such. These things can have an impact on ethnicity, right? People who are not, who may be immigrants. And the Fair Housing Act, unlike other laws, does protect people who are not citizens in the United States. Policies, other policies that we see that I want you to be on the lookout for are policies limiting children, both the number of children that you have. Sometimes you'll see ads that say no more than 2 persons per bedroom. And while that's a general standard, if you apply it too strictly, it can violate the law and have an impact on families with children. So refusals to sell. Different terms and conditions. If they impose different terms and conditions based on your protected status, that is illegal. And we see that both in the application process and after you're already in the housing. Mr. Yaffe, we're going to talk about issues in just a minute concerning animals. But one of the things we see with terms and conditions, kind of to alert you to, and maybe in follow-up to your question about pets, sometimes we see what's called steering, and that is when the housing agent suggests that because you have an emotional support animal, because you have children, because of this or that, you might want to go to a different, you might feel more comfortable at a different apartment. So when they steer you perhaps to a different apartment complex, or maybe steer you to a particular area within a housing complex, that can be discrimination. Statements, advertisements, and notices that express a preference for one group or another may be discrimination. And retaliation, as I mentioned in the opening, seeing a lot of retaliation. And usually that presents itself when usually the person has requested some sort of a fair housing right. Maybe they have asked for a reasonable accommodation for one of their pets, or excuse me, their service animal. Maybe they have asked for a modification, a change in the premises, or something that they might need. And after they've asserted their right, they begin to get notices of fines and different sort of adverse action. And of course, maybe they're even asked to leave, and that may be discrimination as well. And then you have this other catch-all provision that can basically reach anything that makes your housing, limits your housing choice based on protected category. And let's go to the next slide. And this goes into what we've been seeing a lot in the pandemic. And to your question, Mr. Yaffe, persons with disabilities are actually now, and they have been protected since 1988, but they are now the #1 basis of discrimination complained of. This is a definition of persons with disabilities. And as you can see, it is very broad. It includes your association with someone who has a disability. It includes a physical or mental impairment. And with COVID, right, we've seen a lot of cases under this, someone who is regarded as having an impairment. Basically, particularly in the early days of COVID, if you had COVID, right, people would sort of back, away from you. Well, they should still back away from you if you're not vaccinated. But if you are regarded as having an impairment, you may be considered a person with disability under the Fair Housing Act. It does not include current drug users, but it does include those in recovery. Let's move to the next slide. So if you are a person with disabilities, you may be entitled to a reasonable accommodation or a reasonable modification. And this we see a lot of in the pandemic and even before the pandemic. But in the pandemic, accommodations that people may have needed included perhaps more time to vacate a unit. Maybe you needed some accommodations or special protections in the showing of the unit because you couldn't have people coming in and out and so forth, and different things like that we're seeing in the pandemic that can affect your ability both to secure housing and to remain safe in the housing that you're in. And then the next slide, I think, is these are just, and we're going to post this PowerPoint. I'm not going to go into detail. These are just the requirements for a reasonable accommodation. You do have to request it, but it doesn't have to be in writing. And you need to have it supported by some medical evidence. And this is where Mr. Yaffe's question about pets can intersect, because many people with disabilities, physical or mental, will have an animal, either a service animal or an emotional support animal that has typically been, prescribed by a healthcare provider. And if you have such an animal that has been prescribed by a healthcare provider, then you may be exempt from pet fees and other policies related to pets, because in that instance, your animal is not considered a pet. It's basically considered, sort of like your medicine or an assistive device, something that you need for your disability. So it's exempt from other pet rules. And this would apply, again, both in the home search process. Perhaps you need to have your animal with you when you're seeking housing, and of course, while you're in your housing. And the next, I think, slide is my last. Just wanted to talk with you just a little bit about enforcement options. If you think you might have an issue with fair housing, both either in your housing search or while you're in your housing, give us a call. We can also refer you to some other agencies that can help you. And Tony is going to talk a little bit about at the end about fair housing testing and how that might help you figure out exactly what's going on in your housing situation. And of course, you can file a claim on your own with HUD. That's the Department of Housing and Urban Development within 1 year from the housing discrimination, or you can go directly to court within 2 years. And those are some of the highlights that I wanted to give you about housing discrimination. I'm going to turn it over to Nick now to talk about landlord-tenant, and then we'll have questions.
Thank you. So as we mentioned at the beginning, this is, moving season. So I wanted to go through a little bit about what are some of the tenants' rights under the law. I do want to say, most of this is focused on Illinois state law and some of it on Chicago law. Landlord-tenant in general is very state specific. So I know we have people from across the US on this call and may view it later. So I would recommend consulting your state law on landlord-tenant if you're not within Illinois. Next slide. So what do you do if your landlord refuses to renew your lease? This happens pretty frequently where you're coming up to the end of your tenancy and you'll get a letter or notice from the landlord that states that they no longer want you to live there. First thing we recommend doing is just talk to the landlord. A lot of times just communication between you and the landlord, you'll have a better understanding of maybe why they didn't renew the lease, if there's a possibility of you staying, maybe more time to move. During that conversation, you want to determine, like I said, the reason for non-renewal. Part of that is to see if there's an illegal reason. Professor Bethel just previously talked about fair housing laws. So it could be a pretext for perhaps a fair housing violation. We see this oftentimes where, it may be a family living there or just a husband and wife, and the wife, gets pregnant and has a child. And maybe that landlord doesn't want to rent to families with children. So instead of just trying to evict or say you can't live here because of you're having a child, which they know is illegal, they'll just not renew the lease. The landlord, after giving you notice of not renewing the lease, does have to evict you. As it says here, no self-help. So there's a process, we'll talk about that process here, of how a landlord can evict you, but they can't just change the locks. They can't throw out your things without a proper eviction. If they do that, you want to contact, a lawyer right away. Contact the police. Oftentimes the police will say it's just a civil matter, but sometimes they will get involved to at least get you back into that unit. Another thing you can attempt to do is tender rent. If they accept rent after the expiration of the lease, it would create a month-to-month tenancy. I see a question here. In Chicago and Illinois, landlords don't have to give a reason so long as they follow proper notice. That really depends, and we'll talk about different types of notices here. At the end of a lease, yes, you are correct. They do not have to give you a notice. If you are within a lease, then there are certain things that they must do. The first way they could try and terminate a lease is if you are behind on rent. In those circumstances, they would give you a 5-day notice. So that 5-day notice would be for past due rent only. They cannot include other charges such as late fees, attorney's fees, all of that. 5 days after that notice is served, the landlord could commence an eviction action against you. However, if you pay within those 5 days, the landlord cannot proceed with an eviction. The landlord also is not required to accept rent that is less than the exact amount. So if you're trying to tender partial payment, a landlord does not have to accept that. If you are behind on rent, a few things that you can do is, talk to your landlord again, reach out to organizations, seek assistance. Right now, Professor Bethel mentioned, there was a 2-year eviction ban on non-payment of rent cases that has ended. However, there are lots of organizations that do have money available for rental assistance. Next slide, please. The other way, if you are within a lease that a landlord could attempt to terminate your lease, is if they claimed that you violated some provision of the lease. That tends to be things like criminal activity, fighting on the premises, failure to contract utilities, if you're supposed to put utilities in your name, and the like. So if you get a 10-day notice, it's important to note that acceptance of rent after that notice is a waiver. So if you get a 10-day notice and you pay your next rent, that constitutes a waiver of that notice, unless the breach is a continuing breach. Some of the defenses that you could raise is that the breach never occurred, minor violations, the breach was cured, and not a continuing violation. Another type of notice that they could give is if you are in a month-to-month tenancy, they could give you 30 days notice. And this is, again, could be for any reason or no reason at all, provided that that reason is not illegal under another provision, such as the Fair Housing Act. Next slide. So some of the other defenses that do exist in these claims, and I just want to go through real quick, kind of the procedure. So after you get the 5-day or 10-day notice, if you don't pay the rent, or if you don't move, or if you don't cure the breach, then the landlord does have the ability to file an eviction action in court. Once again, there's no self-help, so they would have to file that action in court and get a judgment. When you go to court, some of the defenses you could bring up is denying the breach, questioning the motivation for bringing the eviction action. So that could be a retaliation claim, either under the Fair Housing Act, which is what Professor Bethel mentioned before, or under other provisions, other landlord-tenant provisions, one of which I'll talk about in just a few minutes. The plaintiff is not a proper party. So if they list, let's say your property is waterside apartments, and instead of putting it under the owner's name, they file it under waterside apartments, a building cannot sue you. A management company could, an owner could, but not a building. So that is a defense that could ultimately get a case dismissed. Next slide, please. The notice was improperly served. So if they didn't, they didn't mail it to the right address, they didn't personally serve you, the like. They didn't comply with any of the statutory provisions. So if they didn't, it's a 10-day notice and they didn't say you had a right to cure, or if it doesn't say at all how you violated the terms of the lease, that would be a defense. The landlord filed the lawsuit prematurely. As I mentioned before, there are these 5- and 10-day notices. If the landlord files an action before that time period expires, that would be a premature lawsuit that could result in a lawsuit being dismissed. Next slide. So oftentimes in non-payment of rent cases, what will happen is a tenant, or you may want to withhold rent because of bad conditions. Maybe it's just not habitable, there's black mold, there's, things are falling apart, your bathroom doesn't work. Under the RLTO, which is specific for the city of Chicago, there are requirements that you have to meet to withhold your rents. The first is there has to be that material non-compliance. So there has to be something, like the mold, like the bathroom not working. Then you notify the landlord in writing of your intention to withhold the rent and the amount which reasonably reflects the reduced value. And then if the landlord fails to correct the condition within 14 days, then the tenant may deduct from the rent the amount stated. Next slide. Yeah. Next slide. This is the one we're just on. Yep. Thank you. So then retaliatory eviction, which I mentioned earlier, under the RLTO, which is in Chicago, here are some of the reasons that that would qualify as a retaliatory eviction. So if you're complaining to the health department for health violations and your landlord turns around and tries to evict you, or if you're complaining to an organization or news media about these conditions, if you're trying to build a tenants union and the landlord turns around and tries to evict you. And then there's the last one here you'll see is the catch-all of exercising any rights or remedies provided by law. Next slide. I wanted to talk briefly about eviction ceiling because we're actually in a very unique time period that is expiring relatively soon in August 1st. So you can see here that the law says that an eviction, if you have an eviction, it can be sealed if the interest of justice is sealing the court record, the parties agree to it, there's no material violation, or the case was dismissed with or without prejudice. Generally, what we have seen prior to the pandemic was this was discretionary among judges. So some judges routinely would seal cases, some but once, some it would be difficult to get it sealed. However, right now, because of the pandemic, if an eviction occurred between March of 2020 and March of 2022, the court will seal the eviction automatically after a motion is filed. So the window is pretty short for this, but it is definitely key if you had an eviction during this time period to attempt to get it sealed because they will seal it by right under this new law. Next slide. And that is all I have for now. I do see there are a variety of questions in here. I will turn it over to Mr. Gomez here, and then we can field landlord-tenant questions after that.
Hey everyone, so I'm going to talk a little bit about, I think this kind of connects what Professor Bethel and Mr. Kurtz were saying, in that what can you do about this in case you wanted to get involved or you have issues, So part of what we do at the clinic is that we do fair housing testing. So what is fair housing testing? It's an investigative tool where we take trained fair housing testers, people who have been trained in fair housing laws, who have gotten some of the information that you've gotten today, just a little bit more of an expanded version. And we send them out to do testing on housing providers in terms of loan or rentals, sale of some type of housing. So where did testing come from? So fair housing testing actually is rooted in the civil rights movement. It is a part of the 1968 Civil Rights Act, and it was championed by MLK roughly a week before he was murdered. And it really, the people who were involved in the civil rights movement when they were coming up with the earlier kind of prototypes of testing, went about it by finding a property that potentially had discriminated against somebody based on their race, and they would send somebody of a certain race and somebody of another race, and that's where we get protected classes, because there were certain protected classes, or there were certain categories of people who weren't allowed to go find certain types of housing. Professor Bethel already talked a little bit about it earlier, but there are multiple different types of state, municipal, and protections in your city as well. And it really depends on where you're living and the types of protections that are available to you. And so what can you do to help fight housing inequity is you can sign up to be a fair housing tester. So fair housing testers are, like I said, trained testers, and we're always looking for more. And they're compensated for their time. When we'll get a property that we think, or a housing provider that we think has potentially discriminated against people, we'll do an investigation, and we're just trying to find out the facts of what's going on with that specific housing. I also wanted to share with you, we'll send it after the meeting too, and I think I can pop it in the chat in a little bit, some resources. One is our website. On our website, we also have different brochures, and booklets that just go over fair housing laws in general. There's different categories that you can search through. We have certain things on senior rights, on refinancing, on a couple different subjects that you could check out. Another resource that you could check out would be HUD, which is Housing and Urban Development. They also take fair housing complaints, and they are the originators of kind of fair housing. You can also check out the Coordinated Advice and Referral Program for Legal Services for anything else that you think could potentially not fall under fair housing or that you want additional advice on. And on that, I think we're going to turn it over to some questions.
Well, thank you so much to the three of you for such a wonderful presentation. And I know there's lots of questions coming in, so we'll do our best to try and get to as many as possible. But I know also you have offered that people can email the law clinic if they have additional questions, if we don't get to them. Let me start with, why do we still have so many segregated communities in Chicago when fair housing laws have been around for so many years? The person then goes on to say, what is it about big cities like Chicago and Milwaukee that seem to make this so much more difficult?
Well, gosh, that we need another lunch and learn for that. But I will say that just because, I mean, honestly, people don't always follow the law. That's why we have the clinic. So even though we have the laws, there still is a lot of discrimination. There still is a lot of it that quite honestly can't be litigated. When I first became a lawyer, I loved to sue people. I just loved it, and I love to go to court every day. But you can't sue people all the time. You need policy changes and such to really make differences here. So we've got a lot of work to do, and we'd love to hear from folks interested in maybe collaborating with us on that, and others here in the Chicago area. In the chat, in fact, someone, Ms. Howard, was talking about there are a number of initiatives going on legislatively, as well as policy-wise, to help us build more equitable and stronger communities following the pandemic, and love to have some folks get involved in that.
Great, thank you. And I agree, this could be a whole nother hour program talking about the segregated communities in Chicago and why, and many facets of that conversation. Another question, what is the rationale why landlords would refuse to receive rent payments from pandemic funds?
Well, I guess you're sort of preaching to, the choir a little bit on that. I mean, I don't really understand it. Some people said they just didn't want to do the paperwork involved, but over the course of time, I mean, the paperwork was never really laborious, and they streamlined the process over time. So I will say this too, what we see often in source of income discrimination, which is what that is, right, is that basically it's a proxy for the landlord doesn't want to rent to these kind of people. They may not want to rent to someone who is on public assistance. They may not want to rent to someone, who honestly they were in the beginning, when they thought who might be contagious. So often the refusal to accept these things is just really a pretext for what's really going on. And I don't know if others have thoughts on it too, but I couldn't understand why people didn't want free money, and I still don't understand it.
Yeah, and just to echo that, I don't understand it either. I do agree with the statements Professor Bethel made. And oftentimes landlords, especially when it is a little bit more laborious, I have heard landlords say, well, it's just easier for me to evict this person and get somebody else in than go through the hassle of it. So I think sometimes it's pretext, sometimes landlords are trying to find the easiest way to do it, which I still don't understand because it's guaranteed money, but those are some of the responses I've heard.
Sounds a little bit like another layer of discrimination. I mean, you're talking about why should you care really where the funds are coming if somebody's bringing the funds, but thank you both. Another question, is there any case law around landlords charging high move-in fees as a form of income-based discrimination?
You know, I have not seen that, but I have not seen such a case, but you know, that doesn't mean that there isn't one out there. There have been, and Nick could talk about this, there have been cases honestly challenging fees that landlords have charged, particularly security deposits, which they say is not, well, they claim it's not a security deposit. They claim it's a move-in fee or something else in order to avoid the protections regarding security deposits. But I am not aware of any law, unfortunately, here in Chicago or in Illinois that limits the move-in fees or other fees. And actually, that's an interesting point, because there are some initiatives underway now to get things like rent controls and maybe some of these limits that you're talking about.
What are some of the best practices for future landlords? So sort of on the other side of the coin. So future landlords to make sure they don't run afoul of Chicago's residential landlord and tenant ordinances. Could probably be a whole nother session about best practices, but maybe just a couple of tips.
Yeah, I think, you know, really following the RLTO if you're in Chicago, and following the RLTO is, and I keep mentioning it for Chicago, but it really does lay out everything you can and cannot do as a landlord. So I do think that that's a good start, right? Following the fair house. It's easy to say follow the law, but you know, if more people just followed the law, it would really be easier. I did want to address too real quick the question before it. As far as fees and charging fees with the RLTO, if you are going to charge a move-in fee, landlords are supposed to provide a list of itemized costs, basically. So move-in fees are not meant to be punitive or a barrier, but rather reasonably related to the cost that the landlord's incurring. So that generally is the case in Chicago, is it's supposed to be reasonably related. So if you have a high move-in fee, certainly you could ask the landlord or potential landlord what the fees are related to. And that can be found within the Chicago residential landlord tenant ordinance. For those that were saying, can we get a source for that? So generally that's what I would look under the RLTO for that.
There was a question that came in, and I'm not sure, I know exactly when it came in, so I'm not sure which regulations the person is referencing, but the question is, how is word about these regulations conveyed to vulnerable populations?
Yeah, and you know, this is a challenge, and we do education and outreach. Other groups do that too, and you know, honestly, you know, there's I don't know what the right word, sort of a self-help function. I mean, people really do have to take the initiative, you know, to kind of learn about these and protect themselves. And that's why, and again, not to sound too altruistic about this, but that's why we appreciate your help, because one thing you can do is help spread the word. This is how you can help honestly be a change agent and get this word out to people. Put the pamphlets in the churches, and you know, in the you know, on the community bulletin boards and those kinds of things. And honestly, particularly this opportunity Nick talked about to have your eviction record sealed. I mean, this is really a terrific window that is going to close in the summer. And honestly, if you without that window, if you have an eviction on your record, number one, it may stay there forever if you don't have a solid reason to get it, wiped away. And two, it really can impact your housing opportunities if you have an eviction on your record. So please, let's get the word out for that. And I do want to emphasize, if we didn't say this, our services are free. Did I say that? Did we say that? So we help people. I mean, we can't take every case, but our price is right. So refer people to us.
And in addition, when it comes to the, I know I've talked a lot about the RLTO, but when it comes to landlord-tenant rights, the RLTO is supposed to be attached to every lease in the city of Chicago. So now it's not always, but it should be. And if it's not, the landlord faces potential penalties for that. But so every lease should include a copy of that, so tenants can be aware of their landlord-tenant rights within the city.
And somebody was asking about what is free they missed, and so we will put the information in there about, again, your contact information and just how to connect with you. Another question: if your landlord makes an effort to solve a problem but can't, do you have the right to terminate the lease early? This person goes on to say, in this particular case, the problem is rats entering the walls, ceilings of the apartment. The landlord has hired people to try and figure out where they're coming from and made some repairs, but they're still finding their way in. So the real question is, can the individual terminate their lease early?
Well, it's a good question. It's an interesting question. It really, I hate to use the lawyer answer, it depends. But it really does depend. And there are circumstances in which we've worked out what's called a mutual lease termination agreement, where both sides basically will agree to terminate a lease due to issues with habitability and all of that. So there are ways to do it, but not always guaranteed, I guess is what I will say.
But is that a scenario in which they could call your office or make an appointment to kind of talk through?
Yeah, absolutely.
Great, thank you. So I think I have time for one last question, which maybe is a big question, but how can I protect myself against housing discrimination? What are some tips you might give individuals?
One thing I would say, actually, just in follow up to some of the terrific questions we have here, is to arm yourself, right, with knowledge of what they can and cannot do, what your rights are. And so sort of be aware of that. I would also say that I would encourage people, and I know this is hard, particularly in this market, but try to present yourself in a pleasant way. Don't give them another reason to, don't you have to put on a suit and tie, but kind of dress, kind of okay, and present yourself well. I have had a lot of cases where honestly, the home seeker was turned down because they presented poorly or kind of had an attitude, if that makes sense. And let's just take that out of the equation. Take that out of the equation, particularly one kind of funny case in that I was litigating went all the way. We actually were taking depositions, and the housing provider said, well, we didn't rent to her because she was dressed like a tramp, and we thought she was going to be operating a business, if you will, out of the apartment. So don't give them that kind of excuse to think. And then the other thing, the fair housing testing we do is huge, because as I said in the beginning, many times if the landlord says the house is not available, or the apartment is not available, sorry. I mean, most of us think that is true, right? We don't think that that is not true. And testing can help see if that is the truth, or maybe they were just saying that to avoid renting to you. So those are some thoughts.
Well, wonderful. Thank you. Oh, was there another thought? Oh, I wasn't sure if I cut you off. Sorry about that. Well, wonderful. Thank you all so very much for this incredibly informative program. And Professor Bethel, I want to echo what you said at the beginning. We are so very proud to have the UIC Law School and be part of our UIC family. and just thrilled and so appreciative of all your wonderful time today, but also all the services that you offer on a daily basis. And so thank you again for being with us for Alumni Exchange. We're really grateful to all of you. And just quickly to close us out, please join us for our next Alumni Exchange program next week on Tuesday, March 1st at noon Central Time, as we'll be joined by UIC College of Health Applied Sciences Professor Dr. Leah Leibowitz. Do you know, or have you had the feelings of doubt, inadequacy, and worry that you'll be discovered as a fraud despite evidence of competency, accomplishment, and success? This is known as imposter syndrome, and Dr. Leibowitz will clarify what it really is and discuss ways to manage it as she presents strategies for combating imposter syndrome. To find a recording of this episode and all of our past episodes, please go to go.uic.edu/alumni exchange. And of course, we would appreciate it if you'll take that quick survey and let us know what you thought about this program and any future programs. Thank you again to all of our panelists again for this wonderful conversation. And thank you to all of you for joining us today. We look forward to seeing you at a future UIC Alumni Exchange program. Thanks again and have a wonderful rest of your day.